Adelekun.
Very good morning to you, my lord, and my ladies. I wanted to just begin, if I may, this morning by picking up 2 points really that were raised, which may be sticklers in the minds of my lady, Lady Rose, and my lady, Lady Arden. Points that, lady, I'm just checking your points that need answers from me. And the first is this sense that the court is concerned that through our interpretation of quox, we're sort of placing the claimants and their solicitors in a more disadvantaged position than prior to the introduction of quox. That somehow we're seeking to make things worse. And the second tied to that was an access to justice point, which my lady raised, that, you know, if there's this set-off operates in costs, won't solicitors be disinclined to take cases on? Now, the two can be grappled with together. I just wanted to make it clear so that the court understands the position in terms of the chronology of set-off and how it operates in personal injury litigation. We started with Lockley and legal aid cases. I'll turn to Lockley in a minute and to Burkitt. But following Lockley, costs orders between a defendant and a claimant in a personal injury claim were capable of being set off, even if the claimant was assisted by legal aid. The consequence of the legal aid retainer would be that the lawyer would suffer a shortfall because he couldn't recover the costs in full from the opponent at normal standard basis rates and would only be paid by the legal aid authority at legal aid rates. So there was a shortfall there for the lawyer, and we'll come to see that in play in Burkitt in a moment. But the court said, no, set-off is permissible. Lord Scott, as we shall see, described it as sort of frankly obvious that it was a just approach to take in these cases. Then we had the Access to Justice Act in 1999, which withdrew legal aid largely, save for some exceptions, in personal injury litigation. And my lord will have a note now from us both at the end of a supplemental bundle that was submitted to the court this morning dealing with legal aid. But we're agreed that in 1999, the Access to Justice Act created a new landscape of success fees and after-the-event insurance in the light of the removal, in large part, of the availability of legal aid in personal injury litigation. The consequence was that the state was no longer paying lawyers, clients were, under conditional fee agreements. In order to encourage access to justice, success fees were recoverable by the solicitors to compensate for the loss that they may suffer when losing cases. Because in the old days, if you lost a case, you'd still get paid by the legal aid authority, at least on legal aid rates. And in order to protect claimants from the consequences of paying adverse costs, which orders were continually and commonly made, you could take out insurance. You didn't have to, but insurance was available to be taken out at a cost to the claimant, which could be recovered from the defendant. Now, in that whole period, from the inception of that new regime, orders for set-off were commonly made. So I'm talking now in the period pre-LASPO. If, for example, the claimant won her personal injury claim, but fell foul of a Part 36 offer, the claimant might be entitled to £40,000 worth of costs from the defendant for the period up to the offer, but be liable to pay £20,000 to the defendant for the period after the offer. It was open, and indeed usual, for the court to order a set-off, so that a net payment was paid by the defendant in that example of £20,000. The critical point, my lords, is that the law left and the procedure left the claimant and her lawyers to sort out the shortfall that flowed from that set-off, which inevitably would flow from that set-off. That set-off would not be covered by the AT insurance. The AT insurance covered the claimant's liability to the defendant to pay costs. Now, that regime continued unaffected. It was a commonplace regime for the entirety of the pre-LASPO period.
Having his experience about assessing the merits of them, to be able to make a profit overall, he would accept some are win, some are lose.
Yes, and that remains the position today, because what happened with these reforms, coming to the third stage, so to speak, the government accepted that the regime was too favourable to claimants. Lawyers were receiving excessive success fees to compensate them for the risks they were taking. And after the insurance premiums were a burden on the insurance industry and defendants. And the system was skewed in favour of the claimant side. And so a cross-check was undertaken. The government introduced the reforms following Sir Rupert Jackson's reforms. And we have to look then and ask, what did he do? So one thing he introduced was QOX. The other, he introduced the abolition of the recoverable ATE premium, so defendants would no longer have to pay that. He abolished the recovery, and the government abolished the recovery of recoverable success fees, but, in answer to my Lady Arden's point, success fees remained chargeable to clients by solicitors. They were fixed by regulation at 25% cap in personal injury cases of the general damages. So there was a moderation to the amount of the success fee that could be charged to clients, but in order to accommodate the access to justice points that my Lady Arden was focusing on, there was an upside still for lawyers, namely they would recover a success fee in successful cases to pay for the lack of success in unsuccessful cases. And I dare say, depending on the intricacies of the funding arrangements they have with their clients, shortfalls in cases that they've been successful in. Now, nothing about QOX changes that situation. Absolutely vital to understand. Because if a set-off is applied as we seek, there is going to be a shortfall which has existed in all of these different funding regimes, legal aid, post-Access to Justice Act pre-LASPO, and post-LASPO, which have to be managed by the solicitors and the clients, and have to be borne by the clients or the solicitors depending on their terms of retainer. So the sense that I got yesterday was that the court was concerned, understandably, that we were seeking to develop an argument that made matters worse for claimants, but QOX is deliberately designed to maintain the status quo as regards the effect of set-off. It's not changing, if our interpretation of the rules don't change the status quo at all. My learned friend's arguments completely change the regime. From a regime in which set-off has been available and used in legal aid post-access to justice regime post-LASPO, to a regime in which you can't have set-off of costs. So all of a sudden, there's no shortfall, and the claimant's lawyers don't have to suffer the shortfall in respect of recovery of costs that they would have suffered prior to the introduction of QOX. Now, that is a fundamental shift in favour of the claimant's side, so to speak, when you're looking at the reforms in the big picture from a helicopter view, reforms designed to rebalance a favourable system in favour of defendants, to rebalance it so that it becomes more favourable to defendants, is now being through the submissions of my learned friend, completely skewed to rebalance, or to what he says, to put the claimant's listers in a more favourable position than he would have been prior to the introduction of Cox, which is completely counter the reforms and their purpose.
I mean, there are some aspects of it that were meant to improve matters for the defendants and some matters that were meant to improve things for the claimants. Or do you say that the reforms were entirely supposed to be favourable to the defendants?
Primarily, the headline desire for reform was driven by an over-generous system in favour of claimant
yes,
lawyers.
And that
There's
was
no question
redressed
about that.
by no longer allowing recoverability of ATE premiums or success fees. And so that was to the detriment then of the claimants. But you say that the policy was that there should be no countervailing help for claimants from this revised package.
Yes, there was no suggestion in none of the reform papers that you see. And I would imagine that if the government and Lord Justice Jackson and the Civil Justice Council and all the various bodies that are involved in the promulgation of these rules thought actually now it's vital that set-off of costs against costs should no longer be available to claimants in personal injury litigation, the rules would say that in spades.
Can I just check whether, on any view, the rule goes quite that far? I'm really following through a point made by Lady Arden yesterday. If you look at 4414(1), which is the primary restrictive Cox provision,
yes,
it says you can't enforce an order for costs to the extent that the aggregate amount of the orders you're trying to enforce exceeds the aggregate of the damages and interest.
Yes.
I turned the knots around but I'm not trying to change the sense of it.
yes,
Suppose you had a case in which the claimant recovers £100,000 damages at a trial, so it's real damages, it's an order for damages.
yes, Cox applies.
No Cartwright problem.
Yes,
You apparently have a ceiling of £100,000 up to which you can enforce your cost orders however you like. And if, and I realise it's a big if, set-off is a form of enforcement, I'm thinking back to Lockley and so forth,
yes,
which you'll come to,
yes,
you could enforce costs against costs up to that cap.
yes.
I mean, I don't see that anything in 4414 prevents you doing that,
No.
but correct me if I'm wrong.
Well, I think that is right. Because
But if you're in a case where you haven't got a cap, or it's a skull cap, because you settled the case and because the claimant didn't get an order for damages, then you can't, because you haven't got any ceiling within which to enforce your cost order.
But the critical ingredient in my Lord's analysis is that enforcement within that rule
Includes set-off.
And my submission will be that it properly construed it isn't.
No, of course I accept that.
But I think on that premise I would agree with my Lord.
No, but I completely accept that it begs that question,
Yes, it does.
which is in a sense what we're all here
Yes, it does.
to find
I'm going
out.
to come to that.
But so, for example, and I'm just looking at the relationship between 4414 and 4412, in a case where you had £100,000 top hat for your cap, there'd be nothing to stop you asking the cost judge to exercise his powers to give you effective recovery, if you like, to make use of the cost orders by exercising his powers under 4412.
We say that. We say that 4412 is available, remains available as part of the court's armoury.
But then the
in
question
Cox
is,
cases.
but is it subject to the cap? And that, I think, just simply takes you back to the question whether set-off is enforcement.
Yes. The cap, we say the cap is a cap on the amount that the claimant is required to pay. It's the amount the claimant is required to pay. That is what the cap is about.
What's the purpose of the words in money terms in 4414? It appears twice. Aggregate amount in money terms of such orders doesn't exceed the aggregate amount in money terms of any orders for damages or interest. As opposed to what terms?
Yeah, it's a fair question, but my submission is that it supports the proposition that I'm advancing, that it's about the maximum cash payment, money terms, the amount of money that a claimant is required to pay by way of cap. So there are ingredients within it, but it's an aggregate of two ingredients that provide a monetary cap on what a claimant is required to pay to a defendant. So,
but following on my Lord Briggs, that then if you did ask the costs judge to set off the costs against the costs up to the amount of the damages, then you would then have to pay the damages in full. You couldn't set it off again against the damages and interest under 4414.
Yes, I mean, to the extent that if you set off two cost orders, there's and in favour of the defendant, there's a neutrality there. There's nothing is payable by the claimant. This is critical. By setting off, all we're doing is seeking to reduce the sum we pay the claimant. We're not asking for payment to the defendant.
No, I understand that.
So if that occurs, sorry, my lady, I interrupted you.
But the point that was being made by my Lady Arden and Lord Briggs was that they suggest that 4414 sets the maximum cap of money that you can against which you can enforce. How you do that, whether you do that by setting off against the damages and interest under 4414 or against costs 4412, doesn't matter. But if you set it off against costs, you can't then also set it off
obviously
against damages.
No, I agree with that. I think we're on the same wavelength. If the defendant set off some costs, has been permitted to set off costs against costs, it's only the balance that hasn't been set off that could be set off against the damages. And if there's no balance, the claimant will get the damages.
Well, my example assumed the damages had already been paid in full. So you couldn't set off against the damages. No shows of action left against which you could set it off.
You could enforce against a sum equivalent to the damages. Okay. That's the important point. And my lord, in terms of your example, under Part 36, the damages are payable. They must be paid within 14 days of acceptance. They disappear. And so you're right. We've got to sort of talk of this in the sense that it's an aggregate sum in money terms. It's not the learned friend talks about the fund and so on. It's not a fund. It's a financial cap limitation on the amount by which enforcement proceedings can be taken against a claimant. Yes. And they could be taken against the claimant's house or vehicle. It won't happen in reality, but in theory and understanding the rules, that's how to look at it. And the court could not enforce a sum against the football pools award, for example, that may have been ordered, or the claimant's Ferrari. So there's some of an equivalent sum to the value of the interest and damages.
But you would accept, wouldn't you, that if you got £50,000 in damages, so you had a £50,000 damages which had not been paid, then if you relied on a set-off against the damages for the purpose of recovering your defendant's order for costs, that would use up the cap, and you couldn't do it again under 4414.
Yeah, no, I quite agree with that.
Yeah.
Quite agree with that.
So in that sense, if it is an enforcement cap, you would use up the cap pro tanto by an enforcement by way of set-off against the damages.
Whether it's strictly enforcement by way of damages, I'm not entirely sure it is.
Well, that's the question we're all trying to answer.
It's the reduction in a sum of money that we could seek to enforce. By set-off is, as I say, creates a neutral balance in favour of the defendant. It doesn't create a liability in favour. The effect of set-off is neutral. Its purpose is to preclude a net liability to the defendant in costs, assuming one sets off the other.
Set off as much as you can against costs, and if there were not enough cost to absorb your costs order, you would then set off against damages and interest.
Correct, absolutely so. And that's what's been happening, as I sought to advance a moment ago, for years and years. And in one sense, I mean, set off, I'm going to come set off, a set off here is not enforcement. It's almost as though it's in lieu of enforcement. Set off, because the genesis of set off is section 51. I know it's a point that we discussed yesterday, but section 51 is all about the court's discretion to make costs orders. It's got nothing to do with enforcement of judgments. And my submission is that where a court makes an order for set off, it's exercising its jurisdiction under section 51 to make an appropriate, fair and just costs order. It's nothing to do with enforcement under 4414. And my Lady Arden said it's important that we look at the meaning of enforcement in context. I totally agree. It seems to me that must be right. And the context here has to be what the rules say about enforcement. Do the rules actually include set off as a form of enforcement? That's a relevant question to ask. They don't. We come to that in a moment. And so that would be an indicator that set off in the context of the CPR is not a form of enforcement. But moreover,
but if it's not,
section 50, sorry, my lord.
If it's not, then why would a set off of costs against damages pro tanto use up your available cap under 44.14.1 if this cap is only about enforcement?
Sorry,
if set off is not about enforcement.
So a costs set off, costs against costs, is a section 51.
Right.
There's a difference with costs against damages, my lord, where in Lockley and in Burkitt, you can see from the analysis that different considerations may apply when you're setting off costs against damages. We in this case are concerned with set-offs of costs against costs. Both concern section 51. Section 51 is all that is engaged. Can I take you, my lord, to Lockley? Can I just have a sip of water? I do, without a glass, I feel somewhat of a thug sort of drinking from a bottle, but do you mind?
You're right.
Yes.
As to what your sort of overarching submission has been this morning.
Yes.
As I understand it, you're really saying that throughout the long period that we're looking at, that you've started off looking at, there has always been set off of costs against costs.
Yes.
And that's run through, and nothing that Quox has come in to change affects that underlying position.
That's right, my lord, yes.
And then do I also understand you to say that contrary to what Mr Mallow said yesterday, where he said we were talking in 44.14 about delineating a fund, your point is it's not a fund, it is the value.
It's a value
of that fund.
Yes, it's the value of two identified aggregate categories, sums, that set a limit on how far you can go to enforce your costs.
Yeah. Okay.
And my lord, as regards the second point, Quox, we looked at why Quox was introduced. I'm not going to go over there because it's so clear. The purpose of Quox was to deal with the ATE problem. It was to say, no longer are claimants liable to pay defendants' costs, save by way of these exceptions, so that ATE insurance was no longer largely required. It's still required, it still can be taken out to cover interim cost orders. But the broad picture was, government wanted to get rid of these ATE insurance premiums and the liability insurance costs that fell on them throughout the noughties. It had nothing to do with set-off. It wasn't seeking to change or alter the court's ability to make the right cost order in the right case. I mean, I'll come back to what Sir Rupert Jackson said in one little paragraph, where he expressly refers to set-off being available under this scheme.
The principal mischief was that the party fixing the agreeing with the insurer, the ATE insurer, the premium, never had to pay it.
Yes, it was
because, as I understand, if you win, the other side pays it, and if you lose, the terms of the insurance are that the premium isn't payable.
Yes, the premium was self-insured.
So that the claimant or his lawyers could agree any kind of sky-high premium for the ATE,
yes,
sure in the knowledge that the only person who ever had to pay it would be the defendant.
That's right. That was the problem.
Yes.
And there was years of litigation about it, of which both the learner friend and I doubtless benefited. But there came a point when the government said, this is unfair, this system. It's too expensive. And so Sir Rupert Jackson looked at the possibility of saying, well, let's just abolish cost recovery altogether. I think from memory, Lord Dyson had flagged the idea of let's just have no cost recovery. So we go to the tribunal system, unless there's abusive conduct or something of that kind. But a midway point was achieved through the QOPS mechanism. None of it was to affect the court's jurisdiction to make cost orders that reflected the justice of the case, including set-off. I mean, set-off, I'll come to Lockley if I may, just to take...
Although Mr. Malalieu was saying yesterday that all orders in legal aid cases were, if they were in favour of the defendant, were not to be enforced without an order of the court, that did not include, or that did not prevent set-off against costs.
Set-off, Lockley decided that set-off was available, costs set-off and cost damages set-off was available in a personal injury claim which is where the claimant is supported by legal aid. We'll come to. Can I just take you to Lockley? It's a very quick traversing of Lockley and then a more detailed traverse of Burkitt. But in Lockley's at page 17. The start of it is 172. And whilst traversing these authorities, I just sort of like my lord and my ladies to have in mind the broad picture point that my learned friend's argument leads to Lockley and Burkitt being of no longer of any application in a personal injury litigation. That's the effect of his submissions. You can't have cost set-off. This is how extreme...
Well, can't you if you've got a sufficient cap? If you've got a £100,000 cap, why can't you do enforcement by way of cost set-off within it?
Well, we say you can, but because the court has the jurisdiction to make that order under Section 51.
Yes, I'm simply questioning your submission that your opponent's case does away with costs and cost set-off altogether.
It's a question you can ask Mr. Malalieu.
Yeah, I will.
But I agree. Mr. Malalieu's argument is that set-off is not available at all between costs and costs. And that does have the effect, I think I'm right in saying, of reducing Lockley and Burkitt into the refuse sack in terms of personal injury litigation, which has been an extraordinary outcome where you don't see that as part of the reform programme anywhere being discussed. And more to the point, the Rules Committee and, as I say, the various agencies involved, the Civil Justice Councils, there would be papers coming out of our ears on set-off. From experience, that would have to be the case. And you would see in 4412, surely you'd say this rule doesn't apply in personal injury cases to which 4414 applies. Lockley, Lord Justice Scott summarised the position at page 176 And this is just looking at the jurisprudence now, my lord and my ladies, as to where what is the sort of basis for set-off. Just going back to basics, at 176, paragraph H, he set out some propositions. A direction for the set-off of costs against damages or costs to which a legally aided person has become or becomes entitled in the action may be permissible. The set-off is no different from and no more extensive than the set-off available to or against parties who are not legally aided. The broad criterion for the application of set-off is that the plaintiff's claim and the defendant's claim are so closely connected that it would be inequitable to allow the plaintiff's claim without taking into account the defendant's claim. As it has sometimes been put, the defendant's claim must, in equity, impeach the plaintiff's claim. Set-off of costs or damages to which one party is entitled against costs or damages to which another party is entitled depends upon the application of the equitable criterion I have endeavoured to express. It was treated by Mr. Justice May and Curry and Co. in the Law Society as, quote, a question for the court's discretion. It is possible to regard all questions regarding costs as being subject to the statutory discretion conferred on the court by Section 51 of the Supreme Court Act 1981. But I would not have thought that a set-off of damages against damages would be properly described as a discretionary matter, nor that a set-off of costs against damages could be so described. The passage which my learned friend referred to yesterday. If and to the extent that a set-off of costs awarded against a legally aided party against costs or damages to which the illegally aided party is entitled cannot be justified as a set-off, 1, the liability of the legally aided party to pay the costs awarded against him will be subject to Section 17.1 and Regulation 124 of the regulations, and 2, the Section 16.6 charge will apply to the costs or damages to which the legally aided party is entitled. Applying these principles to the respective orders made by the District Registrar and by Mars Jones J, I conclude that neither can be criticised. In general, in my opinion, interlocutory costs incurred in the progress of an action to trial and ordered to be paid by a plaintiff to a defendant would in equity impeach the right of the plaintiff to recover from the defendant costs of the action ordered to be paid by the defendant. A set-off of costs against costs, when all are incurred in the prosecution or defence of the same action, seems so natural and equitable as not to need any special justification. I would expect a party objecting to the set-off to give some special reason for the objection. It is, in my opinion, less obvious that a set-off of costs against damages would always be justified. So the strength of the point being made here.
In that subparagraph 5, what does all that reference to Section 17.1 of the 1988 Act of Regulation 124.1?
They concerned the enforcement. Section 17.1 of that was the beginnings of the earlier wording of what became Section 11 of the Access to Justice Act, not to be enforced without leave of the court. So football pool's order. The liability of the legal aid party to pay costs awarded against him. So after a set-off, my lady, if there's a set-off and there's still some costs that are payable by the claimant to the defendant, even taking into account a set-off, the claimant's liability to pay the defendant would be subject to the football pool's order. That's all it's dealing with. So it's dealing with a case in which there remains a net liability of the claimant to pay the defendant some costs.
Regulation
124 is
that concerned the court's jurisdiction to make an order for payment, taking into account the means and so on of the litigant concerned. So football pool's order, for example, if a claimant was to win the lottery in a year's time, then any outstanding costs orders in favour of the defendant could be enforced by the defendant against the football pool's reward. And Regulation 124 dealt with the court's discretion in that regard. So that's dealing, my lady, with a situation where a claimant has a net liability to pay the defendant after set-off of costs and damages.
Right, if you read paragraph 5.
Yes.
as meaning that the protection against enforcement only applies to a net amount of
yes,
costs.
absolutely. Yes, absolutely. Because the earlier paragraphs are dealing with set-off. Anything left, in other words, the court is saying, it's not all bad. You can have a set-off that effectively gets the defendant paid. It doesn't cost the claimant anything in terms of putting her hand in her pocket, save to the extent there's a balance payable by the claimant, in which case the hand will only be asked to go in the pocket if there is money available after set-off. That's how it works. Then going to Burkitt. See, Burkitt's quite interesting because in Burkitt, I appeared for Mr. Buxton, the solicitor who pursued and commonly pursued environmental protection type claims on legal aid. And the effect of the set-off in that case was, as I described earlier, it meant that because the defendant wasn't going to be paying the claimant's costs because of the effect of the set-off, Mr. Buxton's firm would only be paid at legal aid rates from the fund and not be paid effectively his standard charging rates by the defendant, because they would have avoided payment through the set-off. And the Law Society intervened, a bit like April, and supported my arguments that this was really quite unfair to claimants and their lawyers, because it meant that the lawyers were carrying the costs of the claim. The effect of set-off is precisely the argument which April is running, and my learned friend is running in this appeal. And I got really short shrift, and the order for set-off was made. And we'll see how that comes through in the judgment now, if I may, my lord. At page 178 is the Burkitt case.
I'm sorry, can you give me that page again?
Page 178 is the start of the authority.
Thank you.
And it was a significant case. Lord Justice Brooke convened, interested parties, all except, I think, the Bar Council.
Where do we find who the interveners?
There's reference to the Law Society.
Yes, but we don't see it in the heading.
No, you don't, I don't think, my lord, from memory. I don't think you do. You see it only in the narrative, in the judgments themselves. Yeah. 181. Yes, you see it from the representative. So the legal aid...
Thank you, yes.
You're quite right. So the LSE's Policy and Legal Department, the Law Society, and the Legal Services Division of the Respondent. Now, paragraph 5 of the judgment, just introductory, you'll see that the court made the observation that the one person who was not going to be paying these costs was Mrs. Burkitt, because she had a legal aid certificate with a nil contribution. And the figures are set out. Mr. Value took you to the figures, so I don't want to dwell on them at paragraph 10 of the judgment. And, my lady, just to assist you in your questions of me earlier, lady, you'll see paragraph 25 and 26 references to section 17.1 and regulation 124, which you asked me about, which may help. That's the football pools order regime. The court referred at paragraph 28 to the passages that I took you to a moment ago, the 5 propositions of Lord Scott. Lord Justice Scott then was in 28. And at 29, the court said this decision has been applied in practice on many occasions in the last 12 years, and unless there is any significant difference arising from the new statutory regime, it would ordinarily be treated as binding on us. And then there was the court referred at paragraph 30 to a line of authority, Anderson and Hills, and rear debtor, which Mr. Buxton was seeking to rely upon to argue that there was no mutuality in the debts between the two, the defendant's liability for costs and the claimant's entitlement to receive costs. And we'll come back to them in a moment. Costs and set-off is dealt with at paragraph 32. In short, Mr. Justice Newman ordered that the counsel, being the successful defendant before him, should receive its costs, but that the order should be effected by those costs being set off against the costs ordered to be paid by the defendant to the claimant in the proceedings in the delay issue, that set-off being limited to the amounts of costs assessed as owed by order of the House. The effect of this will be to reduce by £35,000 the costs which the claimant would otherwise, however, notionally have expected to receive. So that's a £35,000 shortfall. At 33, in normal circumstances, this would have been an uncontroversial order. It is contended, however, that everything changes where, as here, the claimant is in receipt of funding from the LSE. The first and main argument advanced on behalf of the claimant, which was supported by both the LSE and by the Law Society, is it was not open to Newman J as a matter of law to make the order that he did. This, it is important to note, is not an argument about the way in which the judge exercised discretion, but rather that he had no power to do what he did. The reason for this, we were told, is because the costs ordered to be paid by the defendant in the House of Lords belonged not to the claimant herself, but to the LSE. They could not therefore be set off against the costs ordered to be paid by the claimant to the defendant by Newman J, because there was no mutuality between the two debts. And the court at paragraph 34 observed that the financial interests in the appeal were that of the lawyers who appeared for Miss Burkitt on the delay issue, the last few sentences of 34. The court then looked at the nature of the court's jurisdiction as to costs, which you were taken to yesterday by my learned friend Mr. Mallew at paragraph 37 and 38, confirming that costs set off of costs against costs within the proceedings falls within section 51, which is why I say, and we'll say later, that it's not an enforcement. It's a jurisdiction exercised under the court's statutory provisions of section 51. There's then consideration of set off as a defence to a substantive claim, which I don't need to deal with. And then can I take you to paragraph 50, cost protection at first instance. The argument rests on section 11 of the Access to Justice Act. Now, just to help, paragraph 50, my lady, and just to help you, my lady, here, section 11 was the new version of what was section 17. So it's the football pool's order under the Access to Justice Act.
When you say the football order, you mean
it
was the provision that said that orders for the payment of costs by a legally aided party were not to be enforced without the leave of the court? Without
the leave of the court, yes. I apologise for the colloquial summary, but yes, that is correct. And section 17 was replaced by section 11 of the Access to Justice Act. As you can see, my lady, at paragraph 50, section 11 limits the costs payable by an assisted person to those which it is reasonable for him to pay. The short answer to it is that given by Lord Justice Scott in Lockley, and the court cites Lord Justice Robert Walker in Hicks and Russell Jones Walker, which I'll come to in a moment, a set-off does not place the person against whom it is asserted under any obligation to pay, but merely reduces the amount he can recover. We do not agree that this approach is artificial or contrary to the spirit of cost protection. The latter is not an absolute right, but something carefully moderated by specific statutory provisions to which the judges of the cases just cited made careful reference. So here is the Court of Appeal saying what I've been saying from the outset, that set-off is not concerned with an obligation to pay that could then be enforced. It's a mechanism to reduce the amount that he can recover. And so just as set-off wasn't in conflict with Section 11 or Section 17, it's not in conflict with 4414. That's the reason why it's not referred to. Absolutely, my lady, yes. And we get, if I could, sorry, my lady, you were about to ask me a question.
I was going to say, every time you get an interim order for costs in your favour, it's a flawed asset, because at the end of the day, there's going to be a netting out, because that's the prima facie equitable solution. Yeah.
That's right. That's absolutely right. And at 66, this deals with a point made by Lord yesterday, by Lord Briggs, about the timing of when 4412, where you were saying that it's at the assessment. 4412, if we could just go back to it, if we could just keep your thumb on page 192 let's go back. Set off, where a party is entitled to costs, is also liable to pay costs. The court may assess the cost which that party is liable to pay. This particular provision of 4414 is dealing with, it presupposes a party is liable to pay one set of costs to one party and the other party is liable to pay to the other. This provision is making it clear that the court may assess the costs which that party is liable to pay and make an order for set-off. It's slightly different. 4412. It's no different in principle to what the court is looking at in Lockley and Burkitt, which is where the court is not actually assessing the costs, but is making an order for costs and says, it's right in this case that you should get your costs up to a certain date, but I think you should get your costs from another date, and I'm going to order the two to be set off. The order can be made in advance of the quantification of the assessment of the sums, and often is, in fact, on an estimate or broad analysis. I mean, there might be obvious cases where the defendant's costs are so large, particularly now in the modern day where we have budgets and so on, and statements of costs. Assessments are expensive. So the judge can obviously see that the costs of the defendant far exceed the claimant's, or vice versa, and can make an order for set-off. And this is what paragraph 66 I was about to take you to reinforces my submission that the order for set-off is an order for costs, because in this passage, Lord Justice Brooke, in referring to the redebtor cases and Curran Boxall, which was the mutuality of debt cases, which I sought to introduce into the argument and failed, he said, it was understandable that in those circumstances the court should emphasise, admittedly in very general terms, that the interest was indeed that of the fund rather than of the assisted party. But the court, in addressing as it did the enforcement stage, came nowhere near to considering the issue that arises on the present appeal, which relates to the exercise of the court's discretion in deciding what cost order should be made in the first place. In other words, should an order for set-off be made? It's the clearest example of the Court of Appeal distinguishing between enforcement and the promulgation of a costs order by way of set-off. Because rear debtor was all about enforcement. Now, at paragraph 67, both Mr. Bacon, who appeared for the claimant, and Mr. Cooksley, Queen's Counsel, who appeared for the Law Society, gave us examples of the way in which the Lockley approach to set-off might operate harshly and in a manner contrary to the financial interests of the lawyers who acted for the client in receipt of LSC funding, echoing, if I may say so respectfully, the concerns that my Lady Arden yesterday raised and my Lady Rose raised yesterday about the effect of set-off is going to make the solicitors or the client to put them in a financially worse position. It was a point I sought to develop in this case to say there shouldn't be a set-off because of the cost protection that's afforded by Section 11. For example, in a case like the present, he went on to say, specialist counsel might be instructed in the House of Lords, and after they won an appeal at that level, they might find their fees slashed as a result of a subsequent adverse decision in the case when they were no longer instructed. We do not see how considerations like this can affect our interpretation of the Act and the regulations. So that's the ability to set off costs and the effect of cost protection under Section 11 of the Access to Justice Act. If Parliament had wished to insert into the legal aid scheme an overriding lawyer's lien of the type imposed by rule in the middle of the 19th century, it could have done so at any time during the last 50 years, but it has chosen not to do so. Now, although this case concerned the remuneration of lawyers out of public funds, precisely the same point is made in this case.
The claimant's lawyers were going to be paid, but from the legal aid fund.
But they're not getting success fees under legal aid, under the new regime.
Under the Burkitt regime.
No, under the Burkitt regime, they would be paid something in terms of their legal aid rates.
And it's deemed to be a reasonable amount.
But in successful cases, they weren't receiving success fees. It's a very delicate, the system in place.
Yes, but it's a very different system now in terms of risk and reward.
Legal aid legal aid still applies in some personal injury actions. So our note shows that, some serious clinical negligence cases. And one of my points was going to be today that it would be really quite odd if there were two different approaches to set off in personal injury cases where somebody was legally aided and on my lady's analysis, Lockley applies and Burkitt applies and you can have a set off of costs, but not if they're not legally aided. It doesn't seem to us to make any sense that there would be a sensible distinction between the two, particularly when you bear in mind that the system that's been put in place with the Access to Justice Act, which introduced recoverable success fees, didn't alter the balance. It didn't say the cost, the ability to set off costs against costs post-Access to Justice Act should be held back or withdrawn because the lawyers are now being paid success fees. It wasn't affected at all. And even today, we know that success fees are chargeable to clients. That's what the law says. They take 25% of the damages as a cap of the chargeable success fees. And so, to the extent that legal aid has been withdrawn, my lady, so that there is no payment in a lost case or a shortfall case, it's accommodated by the ability of the lawyer to charge a success fee to the client. And also, my lady, it should be borne in mind that, we'll come to it in a moment, one of the reasons why Lord Justice Jackson didn't intermeddle with the solicitor and client relationship is because it's impossible to state, for either of us to state, this is what happens in a case. So many solicitors operate conditional fee agreements under which they agree at the outset, a CFA light, it's called. It's where you just say to the client, I will only get paid in costs what I get back from the opponent. And if there's a set-off, they don't get paid. But they agree to that in their terms of retainer because it's a simple form of arrangement for clients to understand. They're prepared to take the risk of a set-off and not winning a case. After all, they have control of the steps that they take in the proceedings, whether they should take a bad point on an interlocutory hearing, whether they should accept an offer to settle the case. They're in the driving seat. And so there are thousands of solicitors, many, who enter into arrangements of CFA-like terms. The Court of Appeal has looked at CFA-lights in numerous cases, and they continue to exist. So, you know, indeed. So
the Edmondson case was about.
In the Edmondson case, exactly so. And so, you know, one can't really interpret the Cox rule to accommodate what might be the solicitor and client arrangements when there is no standard solicitor and client arrangement, my lady. That would be our concern. So you're right to acknowledge there's a different system in place, but in the sense that the lawyer doesn't get paid something from the legal aid fund any longer, the state doesn't pay it, but the lawyer has the right to charge the client under the conditional fee agreement if it chooses to do so, and can enhance that fee by a success fee, a percentage enhancement on those fees.
If you go so far as to say that where all of the costs are set off, then the aggregate amount in money terms of such orders, to that extent, is nil.
To that extent, yes, that's right. Yes. And my lady, and my lords, paragraph 71, the court recognised the submissions we were making that a set-off in a legal aid case could seriously affect representation in cases, because the example given, the barrister in the House of Lords might not get paid because there isn't enough cash in the pot coming from the defendant. We're of course troubled by the submission we received to the effect that a judgment along the present lines may deter solicitors and members of the bar who would otherwise be willing to act for LSC-funded clients. I mean, I was supported by the Law Society. They came in and supported the submission that this will affect access to justice, and the Court of Appeal rejected it. There can be no doubt that the present scarcity of public funding for such clients is inimical to the future potential of what used to be known as the legal aid scheme. But issues related to public funding are for others to take. Our task is to interpret the present statutory scheme as we find it. Our observations on the impact of this judgment on practitioners in the field of environmental law may be found in an addendum to this judgment. Given that we've satisfied the judge possessed the discretionary powers he asserted, we see no reason to disagree with it. And so my submission is that this consideration by Lord Justice Jackson of Quox, when you take Quox in its stated form, it's all about reducing the need to protect claimants against adverse costs orders that they have to pay, a net liability to pay. That any net liability to pay must be capped at the aggregate of the damages and interest. If there's been a set-off before that, that's fine. Because if all the costs have been set off so that there's nothing further to pay, then there's nothing further to pay. If there's more to pay, then the aggregate cap applies. That's all. Yes, my lord.
Can we just go to paragraph 2 on page 184? Because made a lot of this form of order not to be enforced without leave of the court, etc., and indicated that, as I understood the submission, was really clarifying that it's in the DNA of the personal injury world that enforcement includes set-off. That was my understanding of the submission.
Yes, no, you're quite right to bring me back to it, Lord. So the language, I don't doubt that the language used under section 17 and section 11, I have to be a bit careful because it's not standard. My learner friend accepted that. There are different forms of order, first of all, but it was common, certainly, for orders to be expressed by judges in this terms, not to be enforced without leave of the court, save by way of set-off as against damages and or costs. Now, in my submission, the use of this language of set-off as equating to enforcement is actually incorrect, but it's a useful summary of the court's jurisdiction in respect of set-off in a sentence, but it technically is not a correct reflection of what enforcement amounts to. But it was quite a useful colloquial way of expressing things. That's as far as it goes. I mean, I use the expression in lieu of enforcement, set-off, which I'm thinking of a way of how to express it, but that seems to me to sort of capture the point that it's not enforcement, but it's in lieu of it. It achieves the same effect in the sense that the defendant is made good by virtue of the fact it doesn't have to pay any more. But it's not actually enforcement. So that's my answer, my Lord Burrows, to your point on that.
Costs there, if you're right in saying that actually this order only applies to an amount which is net of any setting off against costs.
Well, here this was much more of a general provision. So here, this is an order made in advance of any costs orders being made in the future and damages being made in the future. One of my points about the jurisdiction to make a costs order. So it's in capturing the possibilities of what might happen in the future. The costs order that's being made here, not to be enforced without leave of the court, save by way of set-off against damages and or costs in the future. So it's respecting two things. You can have a costs against costs set-off, and you can have a costs against damages set-off, which is what you can have. That's all it's doing. I mean, I accept the word enforced is used there, but for the reasons I've given, strictly speaking, set-off is not a form of enforcement in the context of costs against costs, as we see from the Court of Appeal judgment that I've taken you to, Lockley and Burkitt. Costs against damages is arguably different. We saw that in the passages to which I took you to. And I think this sentence, it's a way of sort of amalgamating the court's ability to accommodate cross orders in damages and cross orders in costs in one short sentence. It's not saying what the law is as regards enforcement by way of set-off.
As I understood it, well, whether technically correct or not, that is what enforcement was understood amongst those involved with the personal injury situation. And therefore, yes. A drafting of rules in relation to that area, you might have expected to be on the basis of that colloquialism.
Well, so the number of points arise from that. First of all, when you look at, if practitioners, first of all, there's no evidence of that, but practitioners should read Burkitt. That tells us what the law is. And Lockley, that a set-off of costs against costs is not enforcement. I took you to the passage in Burkitt where Lord Justice Brooke was saying we're not concerned with enforcement, we're concerned with making an order for costs. Point number one. Point number two, 4412 is in section 1 of part 44. It's about the making of cost orders. It doesn't appear in part 70, which is all about enforcement. And context here, I would submit, is the context of the rules as a whole. Enforcement used in one part of the CPR should, wherever possible, surely carry the same meaning that it has in other parts of the rules. And where you have a set of rules that define enforcement, which I'll come to in a moment, part 70, which excludes set-off, there'd be a real danger in the court saying, oh, well, just for one rule, we'll treat enforcement differently from the rest of the rules. That would not be consistent with the clearest of jurisprudence on interpreting the statutes and rules. And as I say, thirdly, in answer to my Lord Borough's point, that sentence is, in my submission, a summary of the practical approach that was taken to cross orders for damages and cross orders for costs. Methods of enforcement are exhaustively prescribed for in the CPR in Part 70 at page 523 of the bundle. They do not include set-off. Rule 70.2, methods of enforcing judgments or orders. And they are listed
Can you give us a page number?
Yes, page 523.
Thank you.
There's a list of methods of enforcement. And they are what you would expect to see. And at 540, my learned friend made reference to section 72 of the County Courts Act. It's just another reference to distinction between set-off and enforcement. Page 540. So section 72 prescribed for set-off of judgments, of cross-judgments. It's not what we're concerned with here, but just using the phrase set-off. It describes a situation where there was one party has obtained a judgment or an order against one another person in one court and the other's got it in another court. The court can set the two off and there can be enforcement proceedings for the balance. But the point about enforcement is that enforcement constitutes procedures to compel compliance with orders. It necessarily arises after the court has made the order for which compliance is required. So there's a temporal point I make. Enforcement occurs after an order has been made. Compliance is then enforced. Set-off, on the other hand, is a primary order that cannot be described as enforcement. It's an order in principle which can be made immediately. Orders for costs for set-off can be made at interim stages. It's not unheard of, as my lords will know, my ladies will know, that for a court to order a claimant to pay costs summarily assessed to defendant, but order that those costs be paid by way of set-off only in the event there is an award of damages. The Hicks case in the bundle is an example of that. And this is reflected in 44.14 too. At page, going back to the rule, 234, which stipulates that orders for costs made against a claimant may only be enforced after the proceedings have been concluded and the costs have been assessed or agreed. Now that wouldn't make any sense if set-off is a form of enforcement, because the set-off will have occurred, the order for set-off will have occurred in the course of the action. So even within the rule itself, the rulemaker is distinguishing between enforcement and set-off. Set-off isn't mentioned. I mean, I say this on more than one occasion in 4414. It's just about enforcement.
The costs made against the claimant should be read as meaning any net order for costs payable by a claimant after set-off of costs has taken place.
Yes.
If you're right on the meaning of enforcement, you don't have to go there.
I don't have to go that far if I'm right about enforcement. That's on the pretext that enforcement is a form of set-off. If set-off has got nothing to do with 4414, 4414 doesn't need any rewriting. Because the set-off will neutralise the claimant's liability for costs. That's the purpose of it. The defendant will receive its cost by way of reduction. It won't require payment from the claimant. I mean, another point by putting it, set-off of costs against costs is by definition capped at the level of the other side's costs. Set-off doesn't operate to sort of give more to a party, it simply operates as a cap. So it's incapable of generating a net cost liability to a defendant. It can't, set-off doesn't create a net liability. The making of an order for set-off will obviate any need for enforcement in respect of money recoverable via set-off. The effect of set-off is it obviates the need for enforcement. So enforcement and set-off are mutually exclusive. In practical terms, we acknowledge that an order for set-off will short-circuit the need for enforcement, but it doesn't somehow transform set-off into enforcement. Indeed, to the contrary, it confirms that they're entirely separate. Could I then, was it 12:45? Could I then go to the Court of Appeal's judgment and explain where I say the Court of Appeal, in favouring my learned friend's arguments, or seeking to at least to indicate the favourability of those arguments, went wrong?
Just before you do, Mr. Bacon, we are grateful to have received, but only I think just before 10:30, some of the academic and other commentary which we were hoping for yesterday. You shouldn't assume we've had a chance to digest it yet, but in the remaining half hour which you have, please feel free to make any comment you want to about it.
In that. So turning to the Court of Appeal's judgment, and page 16. I've got my hard copy somewhere. Paragraph 16, first of all, if I may, it's page 16, corresponding coincidentally with paragraph 16. I'm going to come back to 15 in a moment. I just wanted to make the point that Mr. Manley acknowledged that set-off is not as a general rule regarded as a species of enforcement. It is plain, moreover, that CPR 44 encompasses conventional methods of enforcement such as described in Practice Direction 70. Supposing, therefore, the defendant wished to recover costs from a claimant who had already received sums he had been awarded by way of damages and interest, CPR 44 would allow him to use the ordinary mechanisms of enforcement to the extent of any award. On the other hand, those responsible for co-ops regime will surely also have intended to be possible for a claimant's cost liability to a defendant to be set against the defendant's liability for damages and interest so that the claimant simply receives a net sum. In fact, it would appear far preferable to adopt such an approach where possible. Yet it is hard to see where authorisation, this is where the court, it's hard to see where authorisation for such a course is to be found unless it's in 4414. But with the greatest of respect, the authorisation for the set-off is section 51 and the court's jurisdiction to make costs orders. It's got nothing to do with CPR 4414. And this is a key error in my submission in the Court of Appeal's approach. The court seems to be assuming that the authorisation for a set-off lies in 4414. That simply cannot be right. And so that deals with the second point. The first point at paragraph 15, which the court seemed to like, is
section
the court here, my
51
lady,
enables a set-off of costs against damages or costs against costs only.
Sorry, my ladies.
Well, here the judge is talking about set-off of costs against damages.
Damages and costs, yes.
And the question you're being asked by my lady is whether section 51 covers that or whether it's just about costs and costs.
Costs and costs. Section 51 covers costs and costs.
Yes. But here the judge is talking about costs against damages.
Well, he's talking about the example he gives in respect of claimant's cost liability event to be set off against the liability for damages and interest so that the claimant simply receives a net sum. Yeah. But this is in the context of a submission that you can't have set off of costs against costs.
Yes, but the sentence, yet it is hard to see where authorisation for such a course is to be found, is about what he's just described, which is set off against costs against damages.
But I'm still right in my submission that it's not 4414 that you get the jurisdiction to set off costs against damages.
So
4414 reflects the court's inherent jurisdiction that I referred to in the Buxton case and in Lockley. It's not section 51 in respect of costs against damages, but it is costs against costs.
But I thought you were saying that you appeared to be saying that the authorisation for setting costs off against damages came, you said, from section 51 of the Senior Courts Act and the court's ability to make costs orders.
Yes, but I need to be clear. The jurisdiction to make costs against costs set-offs is section 51. And that is the order that Mr. Manley was seeking to avoid on the grounds that it wasn't permissible. And so as part of that argument, the court was looking at 4414 as the court's jurisdiction to make orders for set-off, and appears to have proceeded on the basis that the court's jurisdiction to make orders for set-off of costs against damages is to be found in 4414 and nowhere else. That isn't correct.
And well, where are you saying that it is found then?
It's found in the Lockley and the Buxton case to which I took you to. It's found in the court's jurisdiction in respect of the actual principles that apply to set-off. That's where it's found. The court's inherent jurisdiction. Lord Neuberger,
if somebody wants to have a row about it, you may end up in court, but it's not dependent upon the court exercising some jurisdiction.
Yes, but the court's jurisdiction to set off. These cases only concern personal injury. The court's jurisdiction to set off damages against costs isn't conferred in cases across the litigation piece. Isn't derived from 4414. It's derived from the court's jurisdiction to make the appropriate order in exercising the court's jurisdiction as regards costs. I mean, there's a good argument to say they're both Section 51. I mean, Lord Neuberger, in the Ike case, if I can just take you to that quickly, it's in the Phillips and Iso case, 376. To 377. Bottom of 376. Can orders for costs be set off against each other? It seems to be clear that judgments for damages going in different ways between the same parties and or orders for costs going different ways between the same parties, whether in different actions or the same action, can be set off against each other, provided that the parties are acting in the same capacity. No set-off would be appropriate for obvious reasons if in one action the party was acting for himself beneficially and in the other he was acting as a bare trustee, somebody else. The existence of a discretion of the court to allow set-off under its inherent jurisdiction in such cases was considered in Edwards and Hope.
So you read that as saying that you could set off
Costs against damages awards?
You can, yes. The court regularly does that. Absolutely, that's the part 36 regime. You have to pay the defendant some damages, but you've got a costs order in your favour following the refusal to accept the offer earlier than they should. They could be set off against the damages. You can have a you can have a set off of costs against costs, and you can have a set off of costs against damages. Absolutely. My simple point is that when the Court of Appeal was looking for the jurisdiction for that, it was saying that it's found in 4414. And my submission is that I don't consider that to be correct. And the reason why the court got to this, because it was trying to sort of equate set-off with enforcement. And because the word enforcement is used in 4414, it was unable to say, well, it is actually a species of enforcement, because 4414 is where you find the jurisdiction. But as I say, that is wrong. That's not where you find the jurisdiction. 4414 respects the fact that such a jurisdiction exists. That's what it does. It recognises and respects the fact that there is the ability to set off. And it's just telling us what the limits of that ability are in personal injury cases. There's a financial limit to how far that point can be taken. It's not conferring the jurisdiction. It's dealing with a cap. And the first point, at paragraph 15, which the court found to be found in Mr. Mellow's favour, was there seems to be force in the other arguments advanced by Mr. Mellow. In the first place, I find it hard to see how cost set-off can be justified on the basis that 4414 deals with set-off without the permission of the court, while 4412 authorises set-off with such permission. As I see it, 4414 is designed to bar any enforcement of cost orders against claimants in excess of damages and interest, unless 4414 or 15 applies, not merely to bar enforcement without the permission of the court. Now, this is, with respect, muddled, this paragraph, So nowhere is the court considering the position that the defendant faces in a case that I described yesterday, for example, where the defendant loses where the defendant wins the action, the claimant loses the action, but has an inter partes obligation to pay the defendant some interrogatory costs on the amendment application. I gave that example. On my learned friend submission, the defendant, having won the action, has to pay all of the claimant's costs of the action and can't even set off the interim costs order that was made in its favour on the amendment application, which seems quite bizarre. My point about paragraph 15 is that the fact that 4412 requires the court's permission is a reflection of the fact that the jurisdiction to make a set-off is derived from the court's jurisdiction under section 51, and a judge must make that decision. It requires the court's permission. In other words, in order to have a set-off, you have to ask for one. They don't sort of appear out of nowhere. The court has to exercise the discretion to permit set-off, and that is permitted and reflected in CPR 4412. That distinguishes it from CPR 4414, which talks about the ability to cap what is chargeable. Doesn't talk about set-off at all. And so the error of the Court of Appeal here is just reading too much into 4414.
Set off then without the permission of the court?
No, you have to get an order from the court to set off costs against costs. You can't just say, I hereby set them off. Unless they agree, if the parties agree, which they probably will, that reflects the fact that the court has to make an order for set off. It doesn't arrive automatically. It might not be fair in a particular case to order set off. It might be fair to order. So the judge has to exercise a discretion. Once that discretion is exercised, then that is an order for set-off. So, as I say, I think the problem with the Court of Appeal's analysis is just reading far too much into 4414. Instead of just treating it simply as a cap, as to the extent to which a claimant is required to pay sums of money to the defendant. And then the paragraph 17 of the judgment, my Lord, there are 3 points that were made which the court says supports the respondent's case. And I just wanted to touch on these. Lord Justice Newey, first of all, said at 17.1 that the rule 4414 doesn't cross-refer to 4412. But with great respect, I say that's an important point in my favour. He seems to have arrived at the proposition that 4412, which would otherwise allow cost set-off, doesn't apply because it's not expressly referred to or cross-referred to in 4414. But surely the opposite must be said, that if 4412 is to be disapplied, it would either 4412 would say so, or 4414 would say so.
Well, if your mindset is that set-off is a form of enforcement,
then it might be different.
Then it's simply a complete ban on enforcement, and it doesn't refer to 4412, but then it doesn't refer to
if your
Part
mindset is
72
enforcement.
either.
Yes, I can see that. But even with that, you'd still mindsets are mindsets. I mean, you'd expect the rules to make. Where are the rules? We all know where the rules say a rule. This rule applies and this rule doesn't. It says so. Well, I mean, this would be the perfect example.
It tries to say so.
Well, ordinarily.
It doesn't say so because it says subject to
Rules 4415 and 4416, but it doesn't say subject to Rule 4412.
As I say, I think as my Lord Briggs was saying, if you start from a proposition that enforcement is set off, then you can. I see where you land up. You can end up with that.
Yeah.
That's the proposition.
That's
that was being advanced against you.
It is, but
Yeah.
for the reasons I've developed.
Yes.
So,
Enforcement isn't
I
set
suppose
off.
your point on 17.1 is it helps you if we have your mindset, and it helps them if they have their mindset,
Yes.
but it doesn't help you decide what the right mindset is.
Yeah. Now, the explanatory memorandum, the explanatory.
you
say that all 4414 is doing is setting a cap not on the total amount of costs that the defendant can recover, using the word recover in a broad sense, but only on the amount of costs he can recover against the damages in excess of any that he's already recouped by setting off an order going in the opposite direction.
Do you have a fallback if you're wrong and it is second proposition? That there is an overall cap on what can be recovered by set-off or in any other way?
There is the potential for the argument that the set-off should operate as between costs so that you arrive at the result that might have been created by the rule, that you can't enforce more than the total sum of the damages. But I would suggest there is no... my principal position is that the set-off of costs against costs takes place in the usual way. The effect of the set-off is not to impose any liability on the claimant, a liability which the court has held the claimant should have. There's a cost order in favour of the defendant. Quox is just concerned with ensuring that the claimant pays no more. There's a cap on what can be demanded from the claimant, from the defendant, by reference to the level of damages and interest. That's all. That's the position. So no, there's no fallback argument. And that's how it's operated. That's how set-off has operated hitherto. It operates sort of almost under. It operates when a set-off is made. A cost order is set off. There are then orders for damages and costs which can be ordered to be set off. That all works fine. All that Quox does is puts a cap on that in personal injury cases. The cap isn't applied in any other cases. I was coming to the third point, which was the explanatory note. And I'll deal with the minister's statement. I don't dispute, my lord, the ability of the court to have regard to the ministerial statement. It was, after all, a statement made by the minister promulgating legislation. But my principal point with respect to both the explanatory note, memorandum, and the minister's statement is far too much is being read into the summary of the position advanced in both papers. That's basically my proposition. The absence of references to words costs or interest, which either helps or doesn't help us, takes us nowhere. It's entirely neutral to the court's task in this appeal. I was going to take you to a passage of the Jackson Reforms which my learned friend didn't take you to, which was from the horse's mouth, so to speak, where Lord Justice Jackson specifically referred to set off in the fixed costs. Sorry? 505, I'm so grateful. 505. 505. Is that, no, it's not the right reference, I don't think. Let me just. So it's 754. For the record, I think 505 in our written case should read 754. I spotted it. 754, paragraph 5.26. This is in respect of fixed costs, the fixed cost regime, which my Lord Briggswell knows all about. Indeed, doubtless other members of the court do too. Here,
I don't think anyone knows all about it.
Not all about it. I overstate the court's
we dabble in it from time to time.
Yes, I know you've dabbled in it from time to time, but coming back to the important point, this passage supports the proposition that Lord Justice Jackson was proceeding on the basis that set-off between the two sums of fixed costs payable to a claimant and a defendant under the fixed cost rules in personal injury claims can be set off against each other. See last sentence.
This, you say, is a description of what one understands the current
Position to be.
Indeed, this is the report dealing with the fixing of costs for both claimants and defendants in personal injury litigation. There's now a fixed cost regime, and those cases attract quocs, which he also recommended, and he proceeded, certainly in this report, on the basis that there can be a set-off. And I say, with respect, that he would have done so with confidence in the light of the way in which the practice has developed over the years that I've already taken to in the personal injury world. Set-offs of costs against costs were common in legal aid, post-legal aid, and they should be common post-quocs. Quocs does not affect set-off. And then the third point, set-off, in the judgment of Lord Justice in paragraph 17, set-off may have been common in legal aid cases. He makes the point that quocs regime does not mirror it, but for reasons I've given, although there are differences in the approach, the broad proposition is the same as a form of cost protection. And under the legal aid regime, the Court of Appeal held that in creating shortfalls through set-off did not undermine cost protection because it didn't require the claimant to pay anything. And that's precisely the position under this regime. Requiring or allowing cost set-off doesn't offend cost protection because it's not resulting in the claimant paying anything to the defendant. I commend to the court the decision of the circuit judge in if I may, Hibbert. It's at page 343 of the bundle. An experienced specialist personal injury circuit judge who, at paragraph 349 to 350, considered how he listened and accommodated the submissions made by Mr. Williams, who was contending that there couldn't be a set-off in the case, largely for the reasons Mr. Williams develops on behalf of APIL in these proceedings, and rejected them wholeheartedly. Hibbert has the benefit of being a circuit judge appointment. My learned friend referred you to another circuit judge's decision, but that decision was pre-Howe, learned friend's case. This was post-Howe and Hibbert, and at paragraph 21, he said, "It's clear to me it's inherently fair, just and reasonable that such a set-off should not only be permitted in principle, but should be allowed in practice. There seems to be no justification for any other form of order, notwithstanding the broader policy reasons underlying Mr. Williams' submissions on qualified one-way cost shifting. The Court of Appeal quite clearly recognised the jurisdiction to make such an order, and acknowledging jurisdiction, the Court of Appeal clearly recognises that qualified one-way cost shifting policy considerations to which Mr. Williams has made reference both in written and oral submissions do not play a determinative part." And he says at paragraph 22, "I go so far as to say that if in the exercise of the court's discretion a set-off were not allowed, the end result would be contrary to common sense, reasonableness and proportionality. In every sense, it would be intolerable to imagine that such a set-off should not be allowed, and accordingly I make an order accordingly." And that was in a case, my lord, where an order had been made at trial, so we weren't affected by Cartwright issues. There had been a costs order made in favour of the defendant following a claimant's claim where she'd been successful. She'd claimed 4 million, but only been awarded 41,000. So she clearly lost. You know, and And the effect of the set-off arguments would be the defendants wouldn't get a penny of their costs for effectively succeeding on the issues in which they succeeded on.
Get their costs.
They get them by deduction.
They win anyway.
They do get them by deduction by set-off, so they're relieved of the obligation to pay the claimant the costs by reference to the entitlements they themselves receive. It's not ideal; they don't get all their costs, but at least they can set off their entitlements.
But if she had completely lost the case and there had been no cross-cost orders,
then the defendants wouldn't have any entitlement.
Yes, they wouldn't get any costs anyway, even though they won. I mean, that's the oddity of the Quox rule, isn't it? So I'm not quite sure how you can pray that in aid as being so anomalous and unfair when that's the whole nature of the regime.
Well, it's not the whole nature of the regime. It depends where you start from in terms of the nature of the regime. The nature of the regime is to encourage Part 36 offers. What's the point of making a Part 36 offer? In the cost proceedings or personal proceedings, if Belinda Friend is right? I ask rhetorically. It blows a torpedo, if I may say so with respect, through a very carefully crafted regime. And the inconsistency of a Learned Friend's case is extreme as well. He appears to accept that under the court's jurisdiction in respect of costs, the court can sort of do a de facto set-off on cost of issues. Well, that is a set-off. Our defendants now then to go before the judge and say, no, we don't want an order for set-off, we'd like you to make a sort of proportionate order because that's the only way we can get round Quox. I mean, it's ridiculous with respect. If you can make an order that's proportionate because it sets off the two entitlements as a matter of discretion under Part 44, of course you can make an order setting off two discrete cost orders made under Part 44. It doesn't make any sense that one should be one should be possible and one should not. It's 2 minutes. Today's supplemental bundle. There is a helpful reference in. There are helpful references in the new supplemental bundle. If I can just have a moment. Professor Professor Zuckerman on civil procedure interestingly produced 2 comments in respect of Quox. The first was in 2013, before Howe. So the sort of the nice thing about this particular reference, it's at page 11. In one sense, the benefit of this this passage is that it precedes any consideration of the matter by the Court of Appeal in Howe. And at paragraph 27, I don't know if your copies are marked with a yellow stripe, but at paragraph 27.180 and 27.17, he specifically refers to the ability to set off costs under 44.12. Mutual cost liabilities may be set off against each other under 44.12. The top of the paragraph on paragraph 27.180.
Yeah.
And that was confirmed, I mean, restated in a slightly different way in Zuckerman on civil proceedings at page 76 to 81, now adding the authority of Howe. Page 76. 76 to 81 is the passage that is the all of it. The effective cost is 28,183, and
So you're saying that this work was saying that that's the way it should operate?
yes, before
And then how confirmed
correct
what was being said?
So that's why in my submission it's particularly helpful. Paragraph 28.185 on page 78 is the post Cartwright and how analysis, again referring to CPR 4412.
Simon French, Blackstone's Guide to the Civil Justice Reforms. You've also put that in the bundle, I think. He's relying on that, as I understand it.
Yes, in that second version of
I think
procedure.
also in the first.
Yes.
Yeah.
And there's some references too in the Blackstone's Guide in 2013. I'm focusing on the 2013 editions because it precedes.
That's what I was referring to.
Well, it was indeed. The others,
Yeah.
a load of friends have put in a whole suite of other points, which doubtless here referred to. But I think it seems to us that the important ones are those pre-Howe commentaries.
So I know you're answering my lord's question, but
so time's
I
up.
can see the time, and we probably have to hear Mr. Mallew in reply in the time that remains.
Thank you, Lord. Thank you.
But thank you very much.
Thank you.
My Lord, thank you, my Lords, my Ladies. If I can perhaps pick up where Mr. Bacon left off with the references to the supplemental bundle that the court received this morning. I think, in fact, the majority of the suite came from a learned friend's side, but I don't think anything turns on that. Of the references that your lordships may find material, as my Lord Burrows has indicated, Professor Zuckerman's comments at page 11 and 76 really pick up on and follow, with no disrespect to him, rather than providing their own reasoning, that of Syme and French in the Blackstone Guide to the Civil Justice Reforms. And your lordships have their extract at, I think, page 5, 10.31 on page 5. It should be, I hope. And it's at the bottom of, or towards the bottom of page 5, the penultimate paragraph, which contains a reference, and this is, as Mr. Bacon points out, a reference before Howe. So back in 2013, the bold statement, 2 cost orders can be set off against each other, and they state that simply by reference to CPR 4412, having set out in the preceding paragraph at 10.30, an explanation that conclusion is the real reason for the Byzantine wording, as they describe it, of CPR 44.14. I think those are the only 2 pre-Howe, if we can put it that way, references in the academic texts. And I mean, no disrespect at all to the authors of the other texts in there, not least because I think I'm the author of 2 or 3 of them, in not placing a great deal of weight on them for the purposes of this argument, because most of them follow the argument that's occurred in either Howe or Adelekun, and perhaps unsurprisingly, since Howe was a decision of the Court of Appeal, and it's unusual for issues of civil procedure to reach this jurisdiction, conclude that Howe has resolved the issue. What they do, and if I may just give your lordship some very brief references, it may not be necessary to turn them all up in the time available, but echoing the description of Simon French of the Byzantine wording, there are a number of interesting references in here. The editors of Cook on Costs, Messrs. Middleton and Rowley, at page 71 of the bundle, refer to this issue as having been an unresolved conundrum. There are additional references, amongst others, to the terms apparently being convoluted and opaque. And your lordships will see when considering these texts that the general view that was taken was that this was an issue which was perhaps not immediately easy to resolve as to what the correct conclusion was, but that it has now been resolved by the decision in Howe, and then a qualification is put on that following the decision in Adelekun. What we would say in respect of that, firstly, no disrespect at all to the work of Professor Zuckerman and that of the authors of the Blackstone Review of the the Blackstone Guide to the Civil Justice Reforms, but there is not a great deal of reasoning to support the conclusion that's given there. And of course, it's a conclusion that's been differed from following detailed consideration of the point and perhaps a further forensic consideration of the underlying materials, of course, by 3 judges, 2 of them giving their own detailed judgments in the Court of Appeal. It's an issue which was open for debate and argument, and we're here having that debate and argument, views earlier expressed without a great deal of supporting reasoning perhaps don't take the debate much further. If I can just give your lordships one further reference, at page 190 in that bundle is an extract from the Green Book, which refers to the tension between 44.14 and 44.12 apparently having been resolved by the decision in Howe. So we have this impression that academics regarded there to be a tension, or the rule to be Byzantine, or to be convoluted and opaque and requiring clarification by decisions of the court. We would say, in fact, that if our case is correct on this, we don't need to go through a Byzantine maze to understand how we can get to a position where set-off of costs and costs is said to be allowed, because it's simply not allowed. And one of the points that we make, of course, going back to the point I took your lordships to yesterday, in the path that this matter followed through the Jackson reports, through the consultation process, your lordships will recall that one of the core concerns expressed in the consultation responses to Lord Justice Jackson's proposed model was the absence of certainty and clarity for claimants as to whether and to what extent there were inroads into the protection that Quox afforded them. And we say that is a core point because, without wishing to tempt fate, it comes back to my point about the self-contained, or perhaps I should stick with the word comprehensive nature of CPR 44 section 2, which is that claimants in personal injury cases and practitioners on both sides, but particularly practitioners on the claimant side, who when receiving instructions from a claimant with a personal injury case have to advise them as to the risks they're exposed to in bringing such a case, should be able to look to a rule which says, this is the rule that tells you have cost protection, and these are the rules within it that tell you when you don't. And the idea that they should have to adopt this Byzantine, to pick up on the word used, path through to see that in fact you have to look at different rules, coincidentally, as it happens, not very far away in the White Book, but nevertheless outside the immediate section, to find what is, if it's correct, a very substantial inroad, whether it's from the claimant's own perspective or the lawyer's perspective, into the effect of qualified cost protection, we say is wholly contrary to the intention, which was to give claimants a clear and certain system of protection, which contained within it the very exceptions that exist to it.
Mr. Mallow, may I fulfil my promise to Mr. Bacon by putting to you the example I put to him this morning? Assume that damages have been recovered of £100,000 by a Quox claimant and paid. And then and suppose it's a case in which costs were sent for detailed assessment. There's a battle royal before the cost judge, lost by the claimant, with a big costs order in favour of the defendant, but for, say, £70,000. And assume that, in the meantime, the claimant also got costs in his favour for the main claim. Would there be, the damages have been paid, so there can be no actual set-off of the defendant's costs order against the claimant's damages, because the shows in action has gone and been replaced by money. Providing that the amount which the defendant seeks to realised by way of a set-off doesn't exceed the damages, is there anything in 44.14 that stops him doing a cost-for-cost set-off or asking the court to do one?
Well, my lord, this is perhaps where the arguments the parties have advanced are sort of tested in the fire of argument and developed, because
yes.
I have to say,
realise it's not this case, the facts of this case, because there is no damages cap.
Indeed, so, my lord, I have to say, from my client's perspective, we can see the force in that point, the way CPR 44.14 would operate would be such that it essentially operates as a cap. But again, a cap on the defendant's ability to give effect to costs orders in their favour, whether by set-off or any other process, such that if a defendant has a costs order in its favour, it cannot gain a benefit from that cost order if that benefit would exceed the aggregate amount in terms of damages and interest that had been awarded to the claimant. And my lord, I have to say, having listened to that exchange earlier and taken instructions, we can see the force in that point, and of course it goes to our point that what is being controlled here are processes of enforcement, including set-off. So what 44.14 is controlling is the entire ability of defendants to give effect to their order, whether that be through traditional forms of enforcement or whether it be through what are traditionally regarded as set-off. But the overarching point is that what 44 section 2 is doing is saying to claimants, you are protected from defendant costs orders, save that defendants may give effect to them in whatever way, including by way of set-off, up to the value of your award for damages and interest. And, my lord, we say...
How you would describe the protection rather than you are protected.
You will never have to put your own hand in your pocket to pay the defendants.
Milady, yes, because we say the protection is not just a protection against having to write a cheque or make a bank transfer or whatever it might be. The protection is that orders for costs made against a claimant may be enforced without permission, but only to the extent they don't exceed the aggregate amount. Now, there are all sorts of scenarios that we can envisage, whether it be a set-off of costs against costs, a set-off of costs against damages, and both of those, and I'll come back to Burkitt in a moment, but both of those in the traditional sense in Burkitt would not have been regarded as the claimant paying anything. That was the core point in Burkitt. Burkitt, with respect to my learned friend's submissions, wasn't about enforcement, because that wasn't the word in the Legal Aid Act that the Court of Appeal was wrestling with. The word in the Legal Aid Act that the Court of Appeal was wrestling with was pay. And I accept, and I accepted in the court below, that set-off doesn't require payment. Of course it doesn't. But we say, and this of course was the point that Lord Justice Newey and Lord Justice Mayles considered had force, rightly or wrongly, which was that 44.14 does appear to set limits on what the defendant does set limits on what the defendant can do with cost orders. And those limits appear to include things more than claimants having to write cheques or make bank transfers. What it does is say that those cost orders cannot be, essentially, we say, of benefit to defendants if the benefit that is sought from them exceeds the value by way of damages and interest only that the claimant has derived from their claim. And so I hope that has answered my Lord Briggs's question.
Yeah, thank you.
If I can then just come back to Burkitt just for a moment. Burkitt starts at page 178. But if I can just pick up on the point I just made a moment ago in terms of what was being decided in Burkitt. If I can take your lordships back to page 184. Now, there are a number of points that arise out of Burkitt. The first is to just clarify what the Court of Appeal, and the same points apply to Lockley, because Burkitt essentially endorsed the decision in Lockley, but we can see it most clearly in Burkitt. The first point is to make clear what was being decided. And the core of what's being decided can be seen at page 185. At page 185, we have a citation of Section 17(1) of the 1988 Act, which, as Mr. Bacon pointed out, was then succeeded by Section 11 of the Access to Justice Act 1999. And this was the statutory provision that provided legal aid cost protection. And what it said was the liability of the legally assisted party shall not exceed the amount which is a reasonable one for him to pay. And so just pausing there, I think it was said a couple of times by Mr. Bacon. Section 17 doesn't actually contain a reference to enforcement. It doesn't say enforcement. It doesn't use that term in it. The issue for the court, as we see from the words of Lord Justice Brooke immediately afterwards, was that the judge below had held that the words liability of a legally assisted party must be construed as a reference to liability to pay. And the issue before the court was whether set-off, in the context of that act, was to be regarded as an obligation to pay or not. And we can see at 27 the conclusion that Lord Justice Scott had arrived at in Lockley, which was that it didn't, and that was the conclusion that was endorsed by the court in this case. So the issue it was deciding was, does set-off amount, in the context of Section 17 of the Legal Aid Act, to an obligation to pay? It doesn't, therefore there's nothing to prohibit it. So that was the issue. As far as enforcement was concerned, 2 points we make in relation to that. The first is that Lord Justice Brooke himself, a paragraph I've taken the court to before, appeared to recognise, and it may be said it was a colloquialism or not, that there was a distinction between the making of the costs order and giving effect to it, including by way of set-off, which was something that the term enforcement could be used for. And we see that on page 189 at paragraph 46. So at paragraph 46, he talks about, prior to that, set-off as a defence to a substantive claim, and then he comes back to set-off in terms of costs, the discretionary balance between two sums of costs, and he deals with in the process. So he deals with the judge deciding firstly what costs order is appropriate, and he notes 3 lines up from the bottom, secondly, an illustrative of the point just made, no right to costs arises until the judge decides that that right exists. So the right is created by the making of the costs order. And then he goes on, since he has discretion in creating the right, step 1, create the right, make the costs order, so he has discretion in deciding the amount in which and the form in which that right should be enforced. In other words, step 2, the ability to order set-off, because that's what he's talking about here. He's talking about the set-off of costs against costs as being step 2, the ability to decide how that right created, the order for costs, should be enforced. And of course, that's the model that CPR 44 section 2 follows, because the whole basis of CPR 44 section 2 is it is starting from the premise that step 1 has taken place. Orders for costs and damages have been made. That's the starting premise. Not subject to rules 44.15 and 44.16, orders for costs may be enforced, ... So the starting premise is step 1 has happened, and then absent 44 section 2, what you would do is you would come to step 2. How can it be enforced, including should the court exercise its discretion to order a set-off? And our case is simple, that in a case involving personal injury following the seismic changes in 2013, you have a 3-step process, not a 2-step process. And so instead of having Step 1, order for costs made. Step 2, should we order set off? You have a 3-step process. Step 1, order for costs made. Step 2, is this a personal injury case? And if so, what does CPR 44 section 2 tell us about any restrictions on what we can do with the order for costs? Step 3, if we are unfettered, for example, if it's not a personal injury case, or if it's a personal injury case and some of the exceptions apply, what should we do about the mechanisms by which, to use the term Lord Justice Brooke used, that those orders can then be enforced, including by way of set-off? And it's for that reason, and I know my lords and ladies have this point, which is whether they accept it or not, of course, is a matter for them, but I don't want to belabour the point. It's for that reason, that sort of terminology, supported by, as Mr. Bacon accepted, the wording that was commonly was his expression, we would say in many cases, until it became overly technical, almost invariably used in this context of the standard legal aid costs order, which again referred to matters not being enforced without leave of course, save by way of set-off against damages and our costs. For that reason that we say the background to all of this is that in terms of that crucial point, and Lord Briggs made the point a number of times, in terms of mindset, we come back to this question, what does enforcement mean in 44.14? Because that colours everything that comes after. And it's in that context we say that however set-off might otherwise be treated, there is substantial force in the point we say that in the context of costs protection, it has always been consistently regarded as something which encompasses whatever way effect is to be given to a defendant's costs order, whether that be by way of step 2, Lord Justice Brooke was referring to, you've created the right, what can you do about allowing effect to be given to it, or in any way we look at it, and whether we're talking about set-off, whether it's in the context of costs or set-off in the context of damages.
But the context has changed. The context is now the context of the CPR.
Milady, it is. On that, of course, there is, of course, already existing dicta twice from the Court of Appeal, in fact, about the importance of construing words within CPR 44 section 2 within its specific context of CPR 44 section 2. On 2 occasions, not this word, if this word had been construed in its context in CPR 44 section 2, we wouldn't be having this argument now in an authoritative way. But in both the Wagoner case, and I'll give your lordships the reference in just a moment, and the Blair and Wicks case, the Court of Appeal was dealing with the question of the word proceedings in the context of CPR 44 section 2. And the word proceedings crops up unsurprisingly in a number of places in the CPR, and it's been a consistent source of trouble. It's made its way to the Court of Appeal on numerous occasions in different contexts, in particular in a costs context, as to what it means. And in the case of Wagoner, the Chancellor, as he then was, made the point that the word proceedings in the Quox rules has to be construed in the context of how it is being used in that section and in those rules. And if your lordships will just give me one moment. Wagoner is at page 196, and the relevant reference is on page 208 at paragraph 38. And if I can just cite that, sorry, it was Lord Justice Voss, as he then was, and not the Chancellor at that point. He says this, in my judgment, the proper meaning of the word proceedings in CPR Part 44.13 has to be divined primarily from the rules on Quox themselves. And so proceedings, bizarrely enough, it might seem odd to this court, is treated in different ways in the CPR. Indeed, there are occasions when proceedings, for example, includes cost proceedings, and there are occasions when proceedings doesn't include cost proceedings. So for some purposes, costs proceedings, detailed assessment, are a discrete set of proceedings. For other purposes, cost proceedings are the same set of proceedings. On some occasions, appeals are the same set of proceedings. On other occasions, appeals are different sets of proceedings. Here, it has always been, to respond to my lady's point, it's always been our case and accepted that there are circumstances where enforcement would not be regarded as encompassing set-off. But we say that doesn't answer the question of whether in this context enforcement does encompass set-off.
Is the word proceeding something which the CPR defines? And is the definition expressed to be?
I don't think there's a specific definition of proceedings in Part 2.
Yes, but maybe it's right. I mean, you have to be careful because the Court of Appeal case of proceedings concerns the definition of proceedings in the Access to Justice Act.
Right.
Recovery of after events insurance previously in proceedings.
No, this is Wagonar. This is not
the other authority, the
Blair. I think Mr. Baker may be referring to a case he and I were in called Hawksford, which was dealing with the definition of proceedings in the Access to Justice Act. I've not gone there, but that was another example of where proceedings was treated differently.
At the time, we'd probably better leave it asleep.
Indeed, but the point about both Wagonar and the Blair case, Lords, I'll give you the reference in just a moment. But the point about both of those is they are construing the word proceedings within the CPR and within the context of CPR 44 section 2, not any wider statutory provision. So, Lords and Ladies, against that background, there are two broad points that Mr. Bacon addressed in some detail yesterday, which we just wish to respond to. The first was that our case can't be correct because the introduction of quox was broadly in return for defendants not being subject to the costs of ATE premiums. And if our case is right, the circumstances in which a claimant would be protected by quox in comparison to the circumstances in which they would be protected or would have been protected by ATE don't completely match. And that there's a mismatch, and that's an indication that our case isn't right. And the second was that he described a number of anomalies, and indeed he came back to his favourite anomaly again today, the one of the defendant winning the case, the claimant winning an interlocutory hearing, and the defendant not being able to set its costs off, and the apparent injustice of that. And if I can just deal with those points in turn. Our core response to that is the process we took the court through yesterday, which we invite the court to consider, as we know it will, as to how these reforms came to adopt the shape that they have. Because we have seen the starting point was very simple. Let's just take away defendants' ability to have costs orders at all. We saw that at page 740 in Lord Justice Jackson's preliminary report. And of course, if that had been seen through, that plainly wouldn't have matched up with the circumstances in which claimants have been protected under ATE. It was just a blanket protection to claimants, and of course it would have given rise to exactly the same, and indeed more of the anomalies that Mr. Bacon has pointed out. That then became qualified. Lord Justice Jackson, as we've seen, identified two prime concerns, the Part 36 point and the frivolous, fraudulent or abusive claims point. And again, what's important to note here is that what was being done was then saying, well, we've recognised the concern, we've recognised that defendants shouldn't be subject to ATE. The simplest way to do that is simply to mean they don't have to pay ATE, and in return, they don't get the benefit of any costs orders in any cases. Not a case-specific match-up, but to achieve a broader policy purpose. Indeed, Lord Justice Jackson, it's referred to, if I just give you Lords and Ladyship's the reference, it's referred to in the supplemental bundle your Lordships have this morning at page 16, at paragraph 5.2, where his report is quoted, he describes this idea of removing the cost burden from defendants in this way as a social policy. So it's a very broad policy. Social policy is the term that's used. But it's recognised that there has to be a qualification to that to deal with the two core concerns that have been identified. And again, there's not an attempt here to precisely mirror the protection that ATE cover offered with the protection that Quox is going to offer. What there is an attempt to come up with a broad system which may give rise to injustice in individual cases, just as the broad system of fixed recoverable costs gives rise to broad, sort of deals with broad propositions and potentially gives rise to injustice in individual cases. Of course, the fixed recoverable cost scheme is the classic scheme where every time the words swings and roundabouts are used. And then we've seen the development of that as it's taken forward through the process where, as I expressly acknowledged in taking the court to the very point, Lord Justice Jackson proposed a model, and under his model as proposed, there would have been scope for set-off of costs against costs. But that model was met with concerns, not just by reference to that, but generally as to its unsatisfactory nature because of its lack of certainty and clarity, and that model was not pursued. And the model was very clearly taken forward, as can be clearly seen from the explanatory memorandum and the statements to Parliament. And at one point in his case, Mr. Bacon said, dealing with his main anomaly, isn't it extraordinary that if the appellant here is correct, the defendant can get to a point in a case, in a personal injury case, where the court has said that it's just for it to have its costs. It's got a costs order, the court said it's just for it to have its costs. But it can't give effect to that just order because it's overridden. Well, my lord, the obvious point to that is on an individual case, that could appear to be unjust. Absolutely. But of course, that is in fact the fundamental premise of Quox. The fundamental premise of Quox, the very starting point of CPR 44 section 2, is a defendant has got a costs order, but the ability to give effect to that costs order is limited. And indeed, in one of the most common scenarios, there are probably two very common scenarios that Quox is dealing with. The first is claimants lose the case completely, and the second is claimants fail to beat Part 36 offers. And in that first of those two common scenarios, if you ask the man on the street, claimant's brought this personal injury claim, it's been completely dismissed. Is it just that the defendant should be compensated for the cost they've had to spend? The obvious answer would be yes. But that individual justice is subsumed in a wider policy for the reasons that had been identified. And so, of course, it's possible to identify examples where it would appear on an individual case unjust to have a situation, whether it's because the defendant has lost or because the defendant has in some way gained an interlocutory order that it can't give full effect to. But that doesn't address the point that Quox starts from that very premise. So, my lord, following that path through, we ended up then with a model. And Lord Justice Jackson's model started from the same basis, albeit it adopted a different approach, which was, let's remove defendants' ability to recover costs. That protects claimants. But we need to protect defendants in certain scenarios. So let's set out the scenarios in which the defendant's protected. To put it another way, let's identify the protection, the blanket protection, and let's set out the exceptions to that protection. Going back to my point as to the importance for practitioners and claimants of being able to know where they stand, we say that is strongly indicative of the proposition that to see what the protection is and to see what the exceptions are to it, we should not be looking any further than CPR 44, Section 2 itself. It sets out in terms the extent to which defendants can obtain benefit from costs orders in their favour, whatever form that benefit may take. Lord, can I just, in the last few minutes, just deal with a couple of further points? Mr. Bacon, close to the end of his submissions, asked the rhetorical question, and I'm going to tempt fate by answering the rhetorical question, but asked the rhetorical question, if the claimant is right, if the appellant is right, what is the point of defendants making Part 36 offers in personal injury cases? Well, the short answer, and it's the answer anticipated by these rules, is that there is substantial point in doing so. The first is that the Part 36 proposition it essentially works on the premise that we're dealing with cases where claimants are likely to succeed and recover some damages, but they're not going to recover as much as the defendant was prepared to pay them. And if that's correct, then there are a number of sanctions which bite on the claimant and a number of benefits to the defendant. The first sanction, of course, that bites on the claimant is that they're not going to be able to recover their own costs for the period after they rejected the offer or after the offer expired, after the end of the relevant period. The first benefit for the defendant is that the defendant's not going to have to pay the claimant's costs for that period. The second sanction for the claimant is that if they've rejected the offer and recovered some damages, having rejected that offer, the Quatch rules allow an exception, which means that up to the level of the damages they recover, the claimant is going to be required to pay in inverted commas, to pay the defendant's costs, but only up to the level of damages and interest that they recover. And that's the second incentive, of course, on the flip side, from the defendant's perspective. Not only have they avoided paying the claimant's costs, but they then benefit by being able to reduce the claimant's damages. That is a fundamental incentive on both sides for Part 36 offers to be treated extremely seriously. There are, of course, incentives for claimants themselves to make offers, the additional benefits that Lord Justice Jackson put into Part 36. So there's nothing in the arguments that we advance, we say, that undermines the primacy of Part 36 in the personal injury context. And of course, there's nothing that this court would want to do to weaken the power of Part 36 in this context. We do say with respect that a significant part of Mr. Bacon's arguments in relation to the anomalies are really railing against the ghost at the feast, the decision of the Court of Appeal in Cartwright, which is not this appeal. But the real upset on the defendant's side is that in that scenario that we have just discussed, they think that the effective ability to reduce damages is likely to be reduced in a number of cases because the damages will not have been awarded under an order of the court. Now, that, if it's correct, is an argument, as I say, against the correctness or otherwise of Cartwright. And whilst I don't remotely cast any doubt on Cartwright at all, it's a binding decision on lower courts of the Court of Appeal. This is not an appeal against Cartwright in any event. Last couple of points, if I may, since I have touched on Cartwright. My learned friend made a couple of references to the judgments of the Lord Justice Coulson in both the case of Cartwright and in the case of Brown. The Cartwright reference, for your Lordship's reference, is page 219, paragraph 23, and the Brown reference, page 154, paragraph 14, where Lord Justice Coulson appeared to support the dictum in Howe, and indeed appeared to suggest that therefore the explanatory memorandum was wrong. And the short point that we make in relation to that is, if those are read properly in context, it's plain that what Lord Justice Coulson is doing, quite rightly in the circumstances, is saying that Howe has decided this point, and therefore the explanatory memorandum must be wrong. Of course, the Court of Appeal is going to follow its own decisions, and therefore if Howe is correct, the explanatory memorandum is wrong. Of course, our case is the explanatory memorandum is right, and Howe is wrong. And with no disrespect at all to Lord Justice Coulson, his conclusion in that regard, that because Howe is correct, the explanatory memorandum must be wrong, does not take the argument before this court as to which is right and which is wrong any further. It did take Mr. Bacon to the point of saying that, yes, the explanatory memorandum was wrong and it should have said damages and costs. And we say really there is his core problem. Perhaps the explanatory memorandum should have said damages and costs. Perhaps, if the defendant had had its wish, CPR 4414 should have said does not exceed the aggregate amount in money terms of any orders for damages, costs and interest. And of course that would have given these rules the effect Mr. Bacon contends for, supported by an explanatory memorandum from the promulgator indicating that that was their effect. But his problem, of course, is that neither the explanatory memorandum nor CPR 4414 do say that. My Lords, finally, talking of spectres at the feast, because it's not received a great deal of attention, your Lordships have the intervention from APEL. I don't represent APEL, it's their intervention. However, we do say that there is some force in some of the points that have been made by APEL. And if I can deal with it in this way, it has never been our case, although it's sometimes been suggested to the contrary, that we are saying that our construction of these rules protect claimants or are intended to protect claimants from liabilities generally to their own solicitor. What we are saying is that these rules delineate the extent to which a defendant can give effect to a costs order in its favour, and that includes ways which, if they were allowed, would increase a claimant's liability to their solicitor, or indeed leave the solicitor out of pocket. But it's the former, it's the point that it delineates the extent to which the defendants can give effect to their costs order that we say is the purpose, not that these are rules which exist in and of themselves to protect claimants from liability to their solicitors. But we do say, from a general perspective, that there is force in the points most clearly made by APEL. Never been the centre of our case, but they're points well made, we say, by APEL, that the practical effect, if the defendant is correct, is not this cost neutrality that Mr. Bacon talks about, but is a system whereby claimants may be exposed to a risk which is not clearly and transparently set out in the rules, is not of itself part of those rules that one might look to see how the claimants are protected by quocs, is not something that standard models of CFA funding so far have catered for by way of providing compensation to claimant solicitors for the risk of it. And of course, those claimant solicitors are themselves already in a more difficult position than pre-April 2013, in that their ability to charge success fees in personal injury cases is now something that has been capped by reference to claimants' own damages. So, my Lords, we do commend the points that APEL has made on access to justice to their Lordships, but our prime argument is the one that we have advanced for the reasons that we have advanced it. My Lords, my Ladies, unless I can assist any further, those are our submissions.
Thank you, Mr. Value. Well, the Court is most grateful to both counsel on their feet and to the, no doubt, hard work of the teams behind them for the quality and the responsiveness of their submissions to judicial observations during the hearing. And we will now take time to consider our judgment. Thank you very much.